amount of compensation under Section 4 of the Employees Compensation Act 1923. Subsection 1. Subject to provisions of this Act, the amount of compensation shall be as follows, namely, Clause A, where death result in from the injury, an amount equal to 50% of the monthly wages of the deceased employee multiplied by the relevant factor, or an amount of 1,20,000 rupees, whichever is more. Clause B, where permanent total disablement results from the injury, an amount equal to 60% of the monthly wages of the injured employee multiplied by the relevant factor, 1,20,000 rupees, whichever is more. Provided that the central government may, by notification in the official gazette, from time to time, enhance the amount of compensation mentioned in Clause A and Clause B. Explanation 1. For the purposes of Clause A and Clause B, relevant factor in relation to a employee means the factor specified in the second column of the Schedule 4 against the entry in the first column of that schedule specifying the number of years which are the same as the completed years of the age of the employee on his last birthday, immediately preceding the date on which the compensation fell due. Clause C, where permanent partial disablement result from the injury. Clause 1. In the case of an injury specified in Part 2 of Schedule 1, such percentage of the compensation which would have been payable in the case of permanent total disablement, as is specified therein, as being the percentage of the loss of earning capacity caused by that injury. And Clause 2. In the case of an injury not specified in Schedule 1, such percentage of the compensation payable in the case of permanent total disablement as is proportionate to the loss of earning capacity as assessed by the qualified medical practitioner permanently caused by the injury. Explanation 1. Where more injuries than one are caused by the same accident, the amount of compensation payable under this head shall be aggregated, but not so in any case as to exceed the amount which would have been payable if permanent total disablement had resulted from the injuries. Explanation 2. In assessing the loss of earning capacity for the purpose of subclause 2, the qualified medical practitioner shall have due regard to the percentages of loss of earning capacity in relation to different injuries specified in Schedule 1. Clause D. Where temporary disablement, whether total or partial, result from the injury, a half monthly payment of the sum equivalent to 25% of monthly wages of the employee to be paid in accordance with the provisions of subsection 2. Subsection 1a. Notwithstanding anything contained in subsection 1, while fixing the amount of compensation payable to an employee is respect of an accident occurred outside India, the Commissioner shall take into account the amount of compensation, if any, awarded to such employee in accordance with the law of the country in which the accident occurred and shall reduce the amount fixed by him by the amount of compensation awarded to the employee in accordance with the law of that country. Subsection 1b. The central government may, by notification in the official gazette, specify for the purposes of subsection 1 such monthly wages in relation to an employee as it may consider necessary. Subsection 2. The half-monthly payment referred to in clause D of subsection 1 shall be payable on the 16th day, clause 1, from the date of disablement where such disablement lasts for a period of 28 days or more. Clause 2. After the expiry of a waiting period of 3 days from the date of disablement where such disablement lasts for a period of less than 28 days and thereafter half monthly during the disablement or during a period of 5 years, whichever period is shorter, provided that, clause A, there shall be deducted from any lump sum or half monthly payments to which the employee is entitled the amount of any payment or allowance which the employee has received from the employer by way of compensation during the period of disablement prior to the receipt of such lump sum or of the first half monthly payment as the case may be. And clause B. No half monthly payment shall in any case exceed the amount, if any, by which half the amount of the monthly wages of the employee before the accident exceeds half the amount of such wages which he is earning after the accident. Explanation. Any payment or allowance which the employee has received from the employer towards his medical treatment shall not be deemed to be a payment or allowance received by him by way of compensation within the meaning of clause A of the proviso. Subsection 2a. The employee shall be reimbursed the actual medical expenditure incurred by him for treatment of injuries caused during course of employment. Subsection 3. On the ceasing of the disablement before the date on which any half monthly payment falls due, there shall be payable in respect of that half month a sum proportionate to the duration of the disablement in that half month. Subsection 4. If the injury of the employee results in his death, the employer shall, in addition to the compensation under subsection 1, deposit with the commissioner a sum of not less than 5,000 rupees for payment of the same to the eldest surviving dependent of the employee towards the expenditure of the funeral of such employee, or where the employee did not have a dependent or was not living with his dependent at the time of his death, to the person who actually incurred such expenditure, provided that the central government may, by notification in the official gazette, from time to time, enhance the amount specified in subsection 4. Section 6 of the Employees Compensation Act 1923. Review. Subsection 1. Any half-monthly payment payable under this Act, either under an agreement between the parties or under the order of a commissioner, may be reviewed by the commissioner on the application either of the employer or of the employee, accompanied by the certificate of a qualified medical practitioner that there has been a change in the condition of the workman, or subject to rules made under this Act on application made without such certificate. Subsection 2. Any half-monthly payment may, on review under this section, subject to the provisions of this Act, be continued, increased, decreased, or ended, or if the accident is found to have resulted in permanent disablement, be converted to the lump sum to which the workman is entitled, less any amount which he has already received by way of half-monthly payments. Section 7 of the Employees Compensation Act 1923. Commutation of half-monthly payments. Any right to receive half-monthly payments may, by agreement between the parties, or if the parties cannot agree and the payments have been continued for not less than 6 months, on the application of either party to the Commissioner, be redeemed by the payment of a lump sum of such amount as may be agreed to by the parties or determined by the Commissioner, as the case may be.